Good morning, may it please the court. I'm David Newman, counsel for HSB Mortgage. We're here today on an adverse ruling on a summary judgment that was entered against HSBC on a counterclaim that was brought by East Bay Country Club Apartments, which is the fee simple owner of the property. Apparently this was a ground lease to which our client's mortgage attached. I think there was some confusion at the beginning of the case regarding the nature of the property. The mortgage itself attached a rider, which was a typical condominium rider, which would govern the borrower's obligations to pay condominium assessments and follow the rules of a condominium association. That's the way that it was pled in the complaint, and that appears to have been an error.
But in the briefing, I noticed that there was a big contention between you and your opponent about whether this was rent on a land lease or whether it was a condominium assessment, and it doesn't look like an assessment, so help me understand that, and I think that's important. I
agree, Your Honor, and I would waive that argument. I reviewed the answer brief and, of course, the initial brief that was prepared by my colleague. I don't recall, I did review it, I'm sure, but upon further review, that argument was not appropriate. Okay. This is a ground lease. There's no question about it. There were two summary judgment motions brought. The first one was denied without prejudice. The second one alleged that the condominium lease had been terminated by the Country Club Apartments on the basis of the borrower, Mr. Mullan, having failed to pay the ground rents. The counterclaim, amended counterclaim, instead of seeking a judgment for rents, which had been the claim brought on the first counterclaim, now sought to extinguish the HSBC mortgage on grounds that it had been properly terminated. Under the ground lease, Section 24 provides certain notices and protections to a first mortgagee. Since their interest only attaches to the actual ground lease, the document or the lease provides certain protections for the bank to pursue.
Well, as defined.
Yes, Your Honor. As defined in the lease. We agree with that. However, a notice was not sent to the plaintiff in this case, which is the mortgage servicer, HSBC Mortgage. During the litigation, an assignment of mortgage was recorded from HSBC Mortgage Corporation to HSBC Bank USA National Association. The appellee's contention is...
So what did the pleadings reflect as far as that assignment was concerned? Anything?
The pleadings did not reflect that particular assignment.
And there wasn't any substitution of parties, or?
That had not yet occurred, that's correct. However, it's clear that a mortgage servicer represents the interests of the owner of the note, which in this case is HSBC Bank. The amended counterclaim, as well as the amended summary judgment, sought to extinguish HSBC Bank's mortgage, as well as HSBC Mortgage. Now, the amended affidavit in support of the amended summary judgment only makes a claim against HSBC Bank N.A., which has not yet been named a party in the case. The bottom line is these issues weren't addressed in the motion for summary judgment. Rule 1.510C requires that the pleader or the movement base its motion with particularity and allege the grounds under which it's entitled to judgment as a matter of law.
There's no transcript of the hearing on the motion for summary judgment, correct?
There is not, Your Honor.
And that's because it wasn't prepared, or there's no court reporter?
I believe there was not a court reporter present. I don't know why I did not handle that hearing. I was not happy that that didn't occur. However, this court does have de novo review and can review the entire record. And
do we know what arguments were made at the hearing, or what concessions might have been made, or anything like that?
I think it's clear from the judgment that was entered that there was argument addressing the fact that the contention of my opponent that HSBC Mortgage Corporation, Mortgage Corporation, the actual party plaintiff, was not an institutional lender and therefore not entitled to any notice of lease termination. That should have been raised in the motion itself because it's a condition preceding to terminating the lease. Notice has to be given. An opportunity to pursue the foreclosure should be given with a waiver of rents during that period. Now, the letter that was sent to HSBC Bank in New York which has the same address as HSBC Mortgage Corporation, merely stated that Mr. Hyam represented the Country Club Apartments, that Mr. Mullan, the lessee, had defaulted in its rents, and as a result, the lease may be terminated.
Now, looking at that notice, I see a certified mail number, and I see what may be a partial address for the property, but I don't see a loan number.
That's correct. There's no reference to a loan number or to a mortgage.
I mean, I wonder how the people at HSC Bank in New York would have been able to reference or pick this up without some kind of a loan number or something on it.
They would have had a difficult time doing that. They service mortgages in all 50 states.
The trouble I have with your position on this, and while it seems on its face like that doesn't feel right, as you read the lease couldn't be more specific about this. It goes to great lengths to define exactly even what an institutional lender would be, and your client doesn't fit any of those categories.
But that evidence was not summary judgment evidence before the court, and we're dealing with a very specific rule, and I would submit that the burden of the move-in in a summary judgment is not light as a feather. They have to show a complete absence of any disputed issue of material fact. In this case, the amended motion was filed before we filed an answer to the complaint. And under the cases that this court has actually determined, the moving party has to anticipate what an answer might raise as any possible defense. It was not raised in the motion that we gave the proper notice and that the bank wasn't entitled to any of the concessions under paragraph 24 of the lease. It wasn't raised until the hearing, and even though there was not a court reporter, that's evident because the judgment itself, I believe it's paragraph 3 of the findings, finds that HSBC Mortgage was not entitled to any notice because it is not an institutional lender. That was not asserted in the moving papers. 1.510C provides the particularity requirement as a matter of due process, so that we are on notice as to exactly what's going to be argued at that hearing.
Well, one of the things we'll never know is what happened at that hearing because there's no court reporter, but it would seem to me if that issue came up, it's likely an issue that was raised by you than by them as a possible controverted issue of fact. So I don't know that it would have been incumbent upon the movement to put that in their motion if it was not the subject that they brought forward. In other words, it sounds like you raise that as a defense.
Well, it's not our burden to prove our defense. It's our burden to raise a disputed issue of material fact, any possibility of one.
But again, we will never know.
We won't know that, but I believe that there's sufficient information in the record for this court to make its own determination as the de novo standard provides the court to do so. And in fact, it was not raised. We weren't prepared for it. When the file was brought to me, I immediately noticed it because I wanted to be able to defend it if all possible and save this mortgage from being extinguished when we've been litigating this case for a couple of years. Their position in the litigation was we want a judgment for rent. Then they changed their mind and they want a quiet title. Well, quieting title is in chancery. It's an equitable proceeding. You've got to do equity if you want equity.
Well, what's in that connection? What's the effect of not sending so much as a copy of this letter to opposing counsel?
I've argued that that would have been appropriate. We were treated as counsel for both the bank and the mortgage company. That's pretty obvious. They're both HSBC, although they are distinct corporations in terms of their formation. HSBC Financial owns both of them. We have been litigating together. It would have been appropriate to send counsel for the bank a notice of default so we would have an opportunity to take advantage of the protections afforded under the lease. And as I said before, I think it's pretty clear that there was confusion, at least on the plaintiff's part, as to what was going on, and it wasn't clarified until the amended counterclaim was filed and the actual termination of lease was presented. And it just indicated we've terminated the lease. It didn't discuss any conditions preceding, and it's incumbent upon them to provide those protections and those notices to the bank. And in this case, they only sent a notice to HSBC Bank, and they didn't send it to HSBC Mortgage, which was clearly the servicing agent for HSBC Bank.
I notice another thing about this letter. There's, I mean, aside from not having the loan number and the legal description, it doesn't say how much they need to pay to cure it. It doesn't explain that the interest is going to be forfeited if it's not paid.
And we've argued that in our briefs. It should have set forth a demand for payment of the rent, perhaps a demand to proceed more expeditiously with your case, or we're going to terminate this lease. That would have been appropriate. But in this case, as I've mentioned, we only have to show the existence of disputed issue of material fact. It's not incumbent upon us to prove our case at a summary judgment hearing. And the fact that it wasn't raised until the hearing caught us by surprise. And as a result, we believe that the entry of summary judgment was inappropriate because the evidence was not, the argument and the evidence was not submitted prior to the hearing. And we'd ask this court to reverse so that we can go back, get the proper notice. And as this court held in the Bank of New York Mellon versus P2D2, a case that's somewhat similar, although in that case the lessor contested the validity of the mortgage at all. It was a ground lease on, I believe, a subdivision lot that had a house on it. They sued the bank and the lessee for quiet title against the bank. They sent the bank a notice in that particular case as well. This court reversed the summary judgment on the same grounds, that the protections for notice and for other protections that the lease provided was an issue of fact that should result in the reversal of the summary judgment. And we believe that it's on point with this case, and we would ask the court to reverse the summary judgment and send this case back to the trial judge. Thank you.
Good morning. May it please the court, I'm Fred Hyam on behalf of the Appellee in this case.
Mr. Hyman, if you don't mind, I just have a question I'd like to ask you right away.
Yes, Judge.
This is a harsh result in a case where the issue really centers around notice, and it seems, the law abhors technicalities and forfeitures based on technicalities. It seems like this is a hyper technicality with regard to the notice. It ended up in a very harsh result.
Well, I think when you take into consideration who the parties to this case are, that it is not such a harsh result. And it is not a harsh result that should have come by any surprise to the appellant in this case, or to HSBC National Bank, who is not and has never been a party to this case. Because
But it's not uncommon for us to see the servicing agencies who act in the stead of the lender. That's a pretty common scenario today.
Yes, Your Honor. And in this case, when the foreclosure was originally filed by the appellant in 2011, I'm sorry, in 2008, September 16th of 2008, HSBC Mortgage Corporation filed the foreclosure. At that time, they were the mortgagee. And apparently, for some unknown reason, while the mortgage foreclosure was pending, the appellant assigned the mortgage to HSBC Bank, and that occurred in May of 2011. While the mortgage foreclosure was pending, and there was no move to substitute parties. There was no move to intervene. There continues to be no action to substitute parties or intervene. The appellant's brief mentions that it hasn't happened yet, and that's true. I don't have any argument with that. It hasn't happened yet. But beginning in 2011, the appellant knew that its pleadings were wrong. and that its borrower, Mullan, only had a leasehold interest. There was a reversionary interest in East Bay Country Club Apartments, Inc., which incidentally had been named in the original mortgage foreclosure action by the appellant, but it was named as the Condominium Association, not as the lessor. And they attempted to obtain service on my client, East Bay Country Club Apartments, Inc., by serving the registered agent of the Homeowners Association. Totally ineffective service. They didn't have the right party named. And it was not until a subordinate mortgagee, Third Federal of Cleveland, filed their counterclaim to foreclose their second mortgage, and they properly identified the association and properly served the association, that HSBC Mortgage Corporation, the appellant, moved to amend their complaint to add the proper association. They never saw it. They never got an order doing that. They never added them. They never deleted or attempted to delete my client from the action. And that occurred in 2009 when they attempted to add the association. And from 2009 forward, they did absolutely nothing to move their mortgage foreclosure forward. An assignment came along. They did nothing to substitute parties. They just sat on it. So given that history and the nature of the pleadings and the nature of their notice, I don't think this works a harsh result. It certainly doesn't work a surprising result. Now, a movant is entitled to a summary judgment if there are no genuine issues of material fact. That burden does not require that the movant negate false issues and negate speculative issues. And claiming that the appellant, who is HSBC Mortgage Corporation, required a special notice and required forbearance is a false issue. It's not an issue. It's not a legitimate factual issue. Because only institutional lenders, as are specifically defined in paragraph 24 of the ground lease, which is included in the briefs, only institutional lenders defined as Federal Savings Bank or Federal Savings and Loan Associations, national banks, state banks, and insurance companies are entitled to this notice and entitled to forbearance.
How would anyone know whether that's a false issue as the amended motion for summary judgment fails to arguably comply with the rule because it doesn't articulate not a single matter of law to be argued? And the rule requires that to be part of the pleading. And that would tell everybody and put everyone on notice these are the issues that we see that have to be resolved. And here there's nothing except a conclusionary summation that we are entitled as a matter of law to summary judgment. So I understand that perhaps nobody challenged the motion's legal sufficiency, but if we're talking about false issues and true issues, if the motion itself would have complied with the rule, it would have articulated the grounds, the legal issues the trial court had to rule upon.
The appellant is now contending that they were entitled to notice of the fact that they were not a national bank, and that is the factual dispute which they asked this court to reverse the judgment over. Well, if you look at the history of the pleadings in the...
Let me ask you this. Why can't that be an issue of fact if we know that HSB Mortgage Corporation is the servicer for a national bank? I mean, didn't you make an argument that under those circumstances they were entitled to notice under the terms of the lease?
The terms of the lease specifically say what a institutional
I know what it
mortgagee
says.
is.
No, that wasn't what I asked you.
I'm sorry, Judge.
I said, well, why can't that be an issue if we know that the actual plaintiff is the servicer for the holder of the mortgage, which is a national bank? Why couldn't you at least make the argument that they'd be entitled to notice under the terms of the ground lease based on those facts?
If you argue that the appellant, HSBC Mortgage Corporation, is entitled to notice as an institutional mortgagee because they are a servicing agent for a national bank.
Well, the key word there is agent, and since when don't we serve agents or notice, agents in lieu of who they're an agent for? I mean, we do that all the time.
If there were no definition of institutional lender contained in the lease itself, that would be a factual argument to be addressed.
Well, except for even the language of your lease doesn't say, and this does not include agents.
It does not specifically negate.
It doesn't say that. Well, doesn't that make it an issue of fact then? Can an agent act for these purposes? And gosh, I mean, we have a whole society built on agents representing principals and receiving notice for them, and it's kind of hard to look at this lease. It doesn't really address that very common issue in the negative, and sort of leaves it open. So maybe it is an issue of fact.
I would disagree that it leaves it open. It specifically says who gets notice, to the exclusion of every other person, every other entity in the world. And since they're not listed, and since it does not say institutional mortgagee means National Savings Bank and its service agencies and its agents, then it excludes those by its simple and plain meaning.
So notice would then go to the lender's registered agent?
Notice would go to the lender as identified, and notice went to the lender as identified in that assignment. They specifically gave an address and said who they were, and that's who got the letter.
Along with that, I mean, why wouldn't it be appropriate when you're involved in this litigation to give a copy of this letter to the attorney for the plaintiff?
Well, the attorney for the plaintiff, HSBC Mortgage Corporation, has never indicated in pleadings that they were attorney for HSBC Bank USA. Two different entities, and we know they're two different entities because of the affidavit in support of their motion for reconsideration.
Don't have any interest in foreclosing this mortgage on behalf of the client? I mean, this wouldn't be of some interest to them?
It may be of some interest to them, and substituting parties might have been some interest to them, but they had months' notice of that, and they never did that. And in the...
You wouldn't even do that as a professional courtesy to opposing counsel?
They received it as part of the second motion for summary judgment because the notice of termination and the notices are in there. And they were already and had been on notice since 2011 that there was a leasehold out there that they hadn't addressed. And they had the opportunity to substitute parties, intervene.
And doesn't the mortgage have on its face a loan number that wasn't included on this letter that went to HSBC up in New York?
There is no loan number on the letter that went to HSBC Bank.
I mean, I wonder how, given the nature of the turmoil in the industry at that time and the number of loans outstanding that HSBC might have had, they would ever have been able to locate and identify this mortgage based on the information that was provided in this letter.
The time for that, I believe, is when they made the loan. When the loan was made, it should have been reviewed to determine that it was not a standard loan. It was that their borrower only had a leasehold. He didn't have a fee simple deed. And at that point, they had the opportunity to say, no, we're not going to make this loan. And, or the opportunity, as Fidelity Federal did in the Appellant versus Fidelity Federal case, which is cited in our brief.
I mean, you know, whether they made the loan or not, they made it. We know they made it. My question to you was about the adequacy of the letter sent to them under the circumstances, not whether they should have made the loan or not.
Again, the notice there is no requirement in the lease which says send notice saying that the notice must contain the loan numbers. It doesn't say that. So I contend that the notice was sufficient, but there's another provision in the lease that we haven't discussed yet, and that is that, first of all, only defined institutional lenders are entitled to notice, and second of all, even if you are a defined institutional lender, you are only entitled to forbearance, which is what they're asking for, the forbearance because of the rent. It says the waiver of rent is conditioned upon the mortgagee promptly exercising its remedy to foreclose after said notice of default and payment of rent and diligently proceeding with said foreclosure. So not only do you have to be an institutional lender to get the notice, you have to do something in order to be entitled to the forbearance. And they didn't do anything. They did absolutely nothing. They didn't substitute themselves for parties. They certainly didn't diligently proceed with the mortgage foreclosure. They didn't do anything. So for that reason, also contained in the lease, they would not be entitled to the forbearance that they're asking for. The Mullan case cited by the appellant principally stands for the proposition that if a borrower has a leasehold interest, even though the mortgage documents may say it's not a leasehold interest, that the mortgage still applies to the leasehold, it applies to what the borrower had. We agree with that, and our position has been that they had a mortgage on a leasehold, but that leasehold was extinguished. What they had the mortgage on is gone. They therefore have no further lien on the property. The appellee initially moved for summary judgment in this case in September of 2012. And both that motion and the affidavit identified HSBC National Bank and the notice that it was given. That was attached to the original motion. Now, the appellant, HSBC Mortgage Corporation, was entitled to no special notice because it was not a defined institutional lender. Now, at that first hearing, the trial judge denied the motion for summary judgment and allowed for an amended counterclaim. He denied it without prejudice. In October of 2012, the appellee filed its amended answer, affirmative defenses, and counterclaim to quiet title. And in that amended counterclaim, it specifically identified HSBC National Bank. It identified any possible interest that it might have, and it produced a copy of the letter and the termination of lease. And that was in October of 2012, a month and a half before 2 months before the hearing on the motion for summary judgment. On January 16, 2013, the appellant filed its response to the second motion for summary judgment and also an answer to the complaint. This was filed 3 business days before the hearing, and the answer to the amended complaint was 92 days late. In that response, the appellant falsely stated that the appellant was entitled to notice and forbearance. And that assertion was in direct contradiction to the lease that it attached, the lease that we've been talking about. The court held a hearing and granted a summary judgment. The appellant argued at the motion for summary judgment they were entitled to notice. I argued that that's not what the lease that you have attached to your answer says. You're not entitled to lease, not entitled to notice or forbearance, and the trial court granted the motion for summary judgment. It's interesting to note that in filing its motion for rehearing, the appellant attached an affidavit of a vice president of HSBC Mortgage Corporation, in which it specifically says, we're a servicing agent, HSBC Bank USA is the bank, not us. There is no legitimate dispute fact here. A conclusory general assertion that is contradicted by the pleadings and the attachments they file to the pleadings does not create a sufficient legitimate factual dispute which would avoid a summary judgment, and respectfully would ask that the trial court be affirmed. Thank you.
With respect to the so-called surprise issue, the lease was terminated before HSBC Mortgage knew about it. It came in a motion for summary judgment, and then it came in an amended motion for summary judgment. HSBC Mortgage is the servicing agent for HSBC Bank N.A. Counsel was aware of that because he saw the assignment of mortgage to HSBC Bank in the public records and attached it to the notice of termination, all done without the knowledge of HSBC Mortgage or its counsel. So we were surprised, and we were surprised at the hearing when a ground not alleged in the motion was asserted as the basis for the actual entry of judgment, which is that HSBC Mortgage is not entitled to any notice and that its mortgage is gone. The money that was used by the purchaser of the lease to buy that unit is just gone because we didn't get a letter.
Aren't you, you're telling us things that we wouldn't know because we don't have a record, right? So you shouldn't be telling us.
I don't mean to quote things that aren't in the record, but I think it's clear from the response that we filed, and I correct that. The response that we filed to the amended motion for summary judgment clearly laid out the fact that we had not received this notice until after it had already been sent to the bank. The letter attached to the motion for rehearing was the letter that was sent by counsel to the bank. I prepared that motion, and I attached that exhibit, and the client executed that particular affidavit to show that HSBC Mortgage is their representative. The complaint itself states that HSBC Mortgage is the servicer for the owner of the note and authorized to bring the present action on its behalf. So the pleadings from day one indicated that HSBC Mortgage was in fact the servicing agent. Just because there was an assignment to the bank doesn't necessarily mean that a substitution would have occurred. It could have, it may not have. It's not always that case. In this particular case, a motion to substitute parties had not yet been filed at the time the counsel sent the letter directly to the bank. As far as the delay in the case, it's not an issue. I don't believe, as far as the summary judgment is concerned, there was never a notice of lack of prosecution or any other order in the trial court compelling the plaintiff to move his case quicker than it did. And I don't believe that that would supplant the longstanding rules of summary judgments, which are that they must show the complete absence of a disputed issue of fact in their moving papers. That they didn't do. And because of that, we'd ask you to reverse this judgment. Thank you.
Thank you, counsel. Thank you both. As I mentioned earlier this morning, we are going to continue to make panel changes. So we're going to take a short recess, change panel. We return for the Rudin versus Romp case. We're going to take a recess after that, change back to the final panel for the last two cases. So thank you for bearing with us this morning, and we are in recess.
It stopped raining and you were smart enough to bring an umbrella. Sit in my room. I just turned on the Why, yeah. There you go. All right for it. This is great, great. Although I have a friend whose brother works for the MLB, and he said they're just gas. Marlins have more championships than the two of them combined. Oh, yes. Yes, oh, yeah. All right, yeah.
So I guess Mr. Sabell.
Yeah. Oh, yeah, that was awesome. I've actually been trying to teach myself Spanish, and that was the article I saw. So I read one baseball article. I went to the American paper. You know what he's saying? He broke his face. Yeah, that was fun. I've already put dibs on Fernandez next time he sells off the team, though.
She's the decision.